Hello, I'm Val Corbett from Independent Colleges. Today I'm going to do a revision of the Contract FE1 syllabus in preparation for the upcoming examination. First of all, from the outset, I'd like to add the caveat that you all know I have no inside information in relation to the examination paper, nor am I going to attempt to predict what topics are going to arise in the paper. Instead, what I hope to do through this revision is briefly scan over the syllabus, focus on those areas on the examination paper which have proven particularly topical with the examiner, and maybe highlight some of the more difficult areas that are open to examination questions. So first of all, just a few general pointers at the very outset, just in relation to approaching the examination itself. Firstly, the main issue that I notice arising from the examiner and the examiner reports, and indeed from other examiners on the FE1s, is students misreading questions. There is nothing worse than misreading a question, launching down the wrong road, writing a 5-page brilliant answer to a question that was never asked. And you know yourselves, you come out of the examination, you conduct the inevitable post-mortem with your friends and your colleagues, which you should never do, by the way, and you discover the mistake you've made. These are very simple things that can be avoided, and it is particularly noticeable under the new examiner that she has commented on a number of occasions, students misread questions. They hurry by reading the question, pick up the wrong issues, and then launch down the wrong road completely. You need at the very outset to take your time reading through the examination paper. Everyone tells you to do it, but it's still good advice nonetheless. Take your time for the first 5-10 minutes to read through the paper thoroughly. Read every single question, reread again, and start ticking off your favourite questions or your best questions, starting with your best first and working your way down. When you launch into then the individual questions, in relation to the problem questions, again, they need particular attention. You need to read through those a couple of times, identifying issues as you go. With the problem question, it is going to be very easy to score very high marks. The big problem with the problem question is identifying the issues. Once you've identified the issues, you're halfway there. Secondly, in relation to the essay questions on the paper, they can be trickier than they first appear. No question will arise in the paper that says, write all you know on. And if you're writing an answer, write all you know on, you've made a mistake. With the essay question, it will ask something specific of you. Only in circumstances where you're screwed for knowledge or screwed for time should you write a general waffle answer. If you've done your work, if you pay attention to your time limits and everything else, you read the question and you answer what is asked. With the essay question, you should start off by answering it, and as you're writing, maybe every paragraph or so, refer back to the essay question on the examination paper and double check it with the answer that you're actually writing. Because in your own mind, you might be writing a brilliant answer, but when you look back on it, it's completely irrelevant. So first thing is beware of the questions, read them carefully, don't fall into any traps. This examiner, in fairness to her, flags the issues very clearly within the question. It's easy for me to say, looking back and not in the examination hindsight situation, with the benefit of hindsight, I should say. But if you look at the questions, even go through the past examination questions, in the problem questions and in the essay questions, she flags quite clearly for students the issues she wants you to discuss. Sometimes she mentions misrepresentation in the question. Sometimes she'll mention frustration in the question. She'll mention, discuss the remedies that are available, or, discuss the different kinds of loss that the plaintiff may be entitled to. So, to her credit, she does do that, and so it is up to you as the student not to get too panicked or too clouded, and to be able to identify and take those hints as you're going through the paper. One other major issue from the external examiner as a general point in relation to contract law is this, her detestation of rote learning. Probably due to the success of some professional law courses that are out there that will remain nameless, that produce materials for the Law Society examinations, it has become evident to the examiners, and this is not confined to contract law alone, it's come up in the other examiners' reports I've noticed in relation to EU law in particular and tort law as well, that students are rote learning their notes, their revision notes, and they're reproducing those, regurgitating those word for word. And this is proven to be an extreme annoyance to the external examiner, and in many ways quite rightly so. Her fear, and I'm speaking specifically about the external examiner for contract, Her fear is that students who are rote learning aren't developing an understanding or a knowledge for the law, and therefore don't have a feel for the subject or the topic. And so when she notices phrases repeating themselves in examination papers, it seems to annoy her somewhat as an examiner, because it tells her that this student maybe doesn't fully understand the area, has learnt off an essay, and come hell or high water, that was the essay that student was putting down on that examination paper. So obviously you have to learn material, you have to learn the cases, you have to learn the facts of cases, you have to learn the legislation. But be very, very, very aware that in this contract law examination, the examiner is looking for your ability to evaluate and apply those principles to the paper at hand. She will be much more impressed with somebody that has a good, solid understanding of the law and is able to use that principles or that understanding and apply it to answer the question that is asked. So please, whatever you do, do not rote learn the material. Learn your cases, develop an understanding for the principles. If you know the principles in relation to this syllabus, you are halfway there to making a good attempt at the contract law examination paper. So a couple other general issues there briefly before I launch into the syllabus itself. Again, make sure that you plan out your answers. You will get marks and good marks. You can pick them up from question to question on your presentation. Many students put a lot of effort into studying. They do an examination paper and then they don't get the marks that they feel they deserve for the work they put in. And that is down to exam technique. So back to the earlier point, read the questions carefully, identify the issues, answer what is asked. Don't put in irrelevant material. Be specific in your answer. Of course, if you don't have enough knowledge to be specific, you're going to have to resort to waffling, but it should be a last resort. Also, in relation to structuring your answer, make sure you have a beginning, a middle, and an end. An opening paragraph, which shouldn't be too long, but introducing the area, maybe identifying some of the main general issues that are involved in the question. The middle part of your answer, whether it be an essay or a problem question, should be the meat and the chunk of your answer, answering specifically what is being asked. In the context of problem questions, be very, very careful when you identify the issues, firstly. You state the law, secondly. Okay, very important. But too many students fail in the next part, and that's the application of those principles and that law to the question that is asked. And again, this is something the external examiner or the examiner has picked up time and time again. She has felt let down by the fact that students are able to identify issues, are able to regurgitate the law, but then drop down dramatically when it comes to applying that law or evaluating that law and applying it to the question that is asked. That is really what separates the men from the boys, because it tells the examiner not only has this person done the work like everybody else who's going to be in that room with you, but also this separates you by saying not only have they done the work, they've developed a keen understanding and an awareness of the issues that they're able to apply them and mold them to any question that is asked on that topic on the examination paper. And to me, that is why she gets annoyed when she sees phrases coming up time and time again, which maybe come from revision material, because that is telling her that students are rote learning and therefore she isn't as confident that they have developed an understanding of the area. Also, again, write as neatly as you can. Do not obviously spend all day writing your answer, but write as neatly and as legibly as you can. Have your paragraphs. Nothing worse correcting a paper as an examiner, and I speak from experience, than seeing a page full of writing in front of you without a space or a paragraph, etc. It also shows that you've organized your thoughts. And if you're able to organize your thoughts and organize the material, it tells the examiner again, this person is familiar with the material, is confident in their knowledge of the material, understands the material, so much so that they're able to organize and answer in a logical fashion. Again, cases, I think, again, should either be underlined or put in a red pen or something like that. Minor issue, but again, as an examiner, you would flick through an answer first, look for key issues, go back, read through it again, think about giving a provisional mark and maybe read through it one more time. So basically, it's a good idea to have cases flagged, because an examiner can flick through it and say, oh, there's a case there, there's a case there, there's a case there, there's a case there. Ah, this student at the very basic level has passed, because I can see they've got all the main cases. And then obviously they'll do a deeper read through after that. Connected with that as well is when you are applying the law, particularly in a problem question, and this idea of evaluation and application, you should see the names of the parties jotted all over each and every page of the answer. So if you've asked a problem question about Mary and Paul, and please advise Mary and Paul in relation to whether the exemption clause applies to their contract or whatever the case may be, I would expect in that answer to see Mary and Paul's name dotted everywhere. Therefore, Mary's case is familiar to X versus Y. Applying the principles in X versus Y, I would advise Paul that. In conclusion, Mary would have a strong argument to so on, and like that. Because again, it shows your ability to apply and mold the principles to answer the question. Again, obvious stuff, stick to your time limits. Give yourself the time limit. Give yourself 5-10 minutes to read the examination paper thoroughly at the beginning. Divide up your time, stick to that time. Do not go over that time. It is a pointless exercise and is a false economy.